and welcome to the third of our series of 4 straight evenings of civil rights celebration and commemoration of the Brown versus Board of Education decision 50th anniversary. We have one more program, and I just want to mention it briefly. Tomorrow evening, Professor Michael Mayer from the university, who is the 20th Century American History Specialist at the U, will be kind of giving a nice sum up of everything, I think, in his talk, How Separate Became Inherently Unequal, Brown versus Board of Education. Professor Meyer has long been interested in this area. He's written extensively about the Brown decision, so we felt really fortunate to have him right here in Missoula. So he is an expert in the field, and it should be a very exciting program. We hope to see many of you back here tomorrow evening at 7 o'clock. One other thing I need to mention, the sponsor of this series of events is the Missoula Public Library Foundation. The foundation has been around for about 10 to 12 years now, and they've done a lot of wonderful things for this library, purchasing shelving, computers, microfilm readers, other equipment, things normally that we just don't have the money for in our regular budget. They've also done a lot of funding of continuing education for library staff people. The library is a better place because of the foundation. There are flyers on that back table. I encourage you to pick one up and keep a hold of it. And when you're thinking about any sort of charitable giving, etc., keep the Public Library Foundation in mind. And with that, I will be introducing our moderator for this evening, Lynette Ivanovich, who is our young adult librarian at the Missoula Public Library.
Thank you. Well, I think I'll have a pretty easy job tonight. All I need to do is introduce these very knowledgeable folks and turn it over to them. I'd like to start by introducing Raymond Cross here in the middle. And Professor Cross is at the law library, or excuse me, the law school. I used to work at a law library, so it trips out off my tongue, you know. So anyway, he's at the law school here in Missoula, and he's a graduate of the John F. Kennedy School of Government at Harvard University, as well as Yale Law School. And he's an enrolled member of the 3 affiliated tribes of the Fort Berthold Indian Reservation, and he began his career as a staff attorney and director of the Indian Law Support Center at the Native American Rights Foundation. To his right, we have, and I'm very nervous about mispronouncing the name, so let's see how well I do, Janet Robideau.
Wrong.
Robideau, okay. She's a long-term activist who moved to Missoula in 1984 to complete her education. She joined MPA with, is that Missoula People's Action? Montana People's Action, when the organization was working on the Universal Health Care campaign. And in 1997, she founded Indian People's Action, which is an MPA project. Janet became the executive director of the organization in 2001 and has received numerous awards for her work in racial justice. And on my right here is Joy James, who's planning to introduce herself, but she is a lawyer in our league and also Montana legislator. Okay. So we're going to go ahead and start. We thought, Professor Cross, if you don't mind starting. And I'll kind of give you a 2-minute warning in about 20 minutes. How does that sound?
First, I want to say what a pleasure it is to be here and to serve with Joy Jane, who I've known for years, has done a great job as a state legislator and representing the Indian people here in Montana. Janet Robideau, who really is a role model for many of the people here that takes the action that us lawyers and law professors only think about and produces results for the Indian people here in our community. And I'd also like to thank the Public Library for hosting this series and you for turning out. And let me tell you what I plan to do. First, I think it's appropriate that we pay tribute to Brown v. Board of Education at its 50th 50-year anniversary, because without that decision, without that 9-0 decision 50 years ago, it'd be unthinkable that we'd even be sitting down here today looking towards that future of racial equality, racial justice, equal opportunity, all those things that the founders of America promised so many years ago, but as of yet remain unrealized. So today, what I'd like to do is to put Brown v. Board of Education, Brown 1, Brown 2, the first case decided in 54, the second case decided in 1955, in some historical context for you. And then I'd like to relate it to the issue of Indian education here in Montana. So let's talk about the big picture first. What Brown v. Board means and why we're paying tribute 50 years thereafter to Thurgood Marshall and those brave lawyers that represented NAACP in that litigation. And then let's take a look at the future for all of Montana peoples, Indian and non-Indian. Talk about what remains undone. Talk about how you and I, by joining together, can help realize the promise of Brown v. Board of Education. First of all, I'd like to place Brown v. Board of Education in historical context as the Supreme Court's Herculean effort to finally fulfill our nation's promise of racial equality that had been embodied in the Reconstruction era's proudest constitutional product, the 14th Amendment of the Constitution, that promises for all of us equal protection of the laws and due process of the laws. Second, I'd like to evaluate those tectonic forces of opposition set in motion by Brown 1 that derailed Brown's vision of a desegregated civic sphere of American public and private life. And third, I'd like to connect Brown v. Board of Education to our own constitutional experience here in Montana. And I'm talking about the adoption of the most unique constitutional provision of any of the state constitutions, Article 10. Article 10 that promises Indian education for all in one of its provisions, and in the sister provision promises a quality education for all children, Indian and non-Indian, in K-12. I'd like to speak just briefly in that regard about the recent decision by Judge Jeffrey Sherlock, holding that vision of quality education remains unfulfilled here in Montana, ordering the state of Montana, the state legislature, to implement that provision. So let's talk first about the Brown decision. The 1954 Brown decision, Brown v. Board of Education, stands as this court's Herculean effort to put our nation back on track towards the idea of real equality, the idea of racial equality, after that effort had been derailed by the court's 1896 decision known as Plessy v. Ferguson. That decision gave legal sanction to what was known as the Jim Crow era credo of a permanently segregated American society. Due credit must also be given to one of the most famous lawyers of the 20th century, Thurgood Marshall. I had the pleasure of appearing twice before Justice Marshall when he became Justice Marshall in the U.S. Supreme Court, the first black man to serve on the nation's highest court. And it was to Justice Marshall, Thurgood Marshall's credit, that he was the lead attorney for the named plaintiffs on behalf of the NAACP. And it was he who helped craft the legal theory of Brown that struck at the heart of the Plessy v. Ferguson doctrine of a permanently segregated America. If those of you that remember legal history, Plessy v. Ferguson spoke to the issue of whether it was constitutional to separate the races into separate accommodations, separate school systems, separate lunchrooms, separate churches, separate workplaces. Justice Harlan, the first Harlan, in authoring that opinion, said, look, if these plaintiffs in Plessy v. Ferguson feel that they've somehow been treated unequally by being required to sit in separate railroad carriages, that's merely a psychic injury. It's merely some sort of psychic injury that cannot be legally cognizable. The court can't take into account how they feel. The court can only look and see whether those railroad carriages are equal. Equal in terms of the purpose of railroad transportation. So way back when, in 1896, the Supreme Court gave legal sanction to the vision of a permanently segregated America that stood until 1954, until the Brown decision of that date. Now, I also had the great pleasure of meeting the lead expert witness who presented the case on behalf of the Brown plaintiffs, Dr. Kenneth Clark from NYU. Dr. Clark's testimony struck at the heart of the idea that psychic injury, a sense of humiliation, a sense of not being equal, was not important. Dr. Kenneth Clark was a psychologist, and what he showed was that separate was inherently damaging, not just to the black children that went to the K-12 schools in Topeka, but also to the non-black children, to the white children. Through extensive testimony, extensive tests, he showed that the idea of segregation wouldn't work because it produced damaged children, damaged black children, damaged white children, and a damaged society. So it was with great pleasure that I have had the opportunity to appear both before Justice Marshall and meet and listen to Dr. Kenneth Clark when he spoke at Yale about his role in Brown v. Boyd. So what was Brown's monumental goal? Well, Chief Justice Earl Warren worked with his colleagues on the court to ensure that it was a 9-0 decision, a unanimous decision, one that proclaimed that the goal of the court's decision was to eliminate root and branch. Eliminate root and branch. The effects of segregation and to forward racial equality. And what was so remarkable about the Brown decision was that it struck at the heart, as I say, of the Plessy doctrine, of the Jim Crow reality of separate life for black and white Americans. What it did was to promise equality through reforming K-12 education in America. And its hope was that these school children, through attending the same classroom, performing together in the same school plays, playing on the same school athletic teams, later attending the same churches, working in the same workplaces, that one day, through re-socialization, through this personal contact, through this process of learning from one another, we move from America that was segregated to an America that was accepting of diversity. Now, it's fashionable today, if you read or go to conferences, as I do in legal academia, it's fashionable today to trash Brown, to say it was based on naive psychology, to say that those 9 justices were judicial activists, to say that their constitutional interpretation of equal protection under the law didn't merit a judicial order nationwide desegregating America's K-12 educational system. Yet, as I say, despite what the legal academics have to say, all of you know that it would be unthinkable to have an America without Brown v. Board, to have a segregated America, to seek to go back to that time when people were judged not by the content of their character, but by the color of their skin. So that the only reason we can have this discussion, and we as Native Americans can enjoy the benefits, just as you are enjoying the benefits of the Brown decision, is to recognize the value, the generosity, the wisdom, and the impact of Brown v. Board. A lot of the legal academics say a year later, the court had a change of heart, whereas the Brown 1 decision was lion-hearted. The Brown 2 decision was faint-hearted. Brown 2 was what's called the remedial order, the implementation order, the order directed to all the school districts throughout the nation saying that you have to take due, deliberate speed to desegregate. And now, some 50 years later, in some ways America remains more segregated than ever. So what I'd like to talk about now is to say the courts have done their part. Brown 1 remains the law of the land. We have to sometimes think outside of the courts. We sometimes have to think about justice within our own communities and our own sphere of actions, as Representative Jane and Ms. Rubidoux. What remains for us to do when we are the inheritors of the legacy of Brown? Let's look at the Montana experience. Let's look at our experience. 1972, the people of Montana adopted a new constitution. They were far-sighted enough to include, out of all the state constitutions, a unique constitution provision called Article 10. That article first commands that the people of Montana respect, value, and produce a K-12 system that takes into account Indian educational values, Indian cultural values, and Indian social needs. The second part of that says it's a constitutional right to a quality education for all students in K-12. Those two provisions read together, the Indian Education for All provision, recently implemented by a bill sponsored by Carol Juneau, representative from Blackfeet, and by Judge Jeffrey Sherlock's decision that orders a new system of school financing to ensure education for all. So let's take a look and think about what it is that's the fundamental character of K-12 education. All of you know that unless we have a view of education that's freedom-centered in nature, that it's not possible for any of our children to exercise any of those more important freedoms. Without an adequate, sufficient education, a child can't exercise political freedom, can't engage in dialogue, can't scrutinize and criticize official action, can't discuss and understand the political significance of issues of the day. Let's consider economic freedom. Without an adequate education, a child can't understand how to use his or her own personal talents and resources, can't make those decisions that can direct his or her life with respect to managing those abilities, those talents, those incomes that make for a great community. And third, social freedom. Without adequate education, a child can't form relationships based on mutual trust, can't engage in interpersonal interaction that furthers his or her interests while also furthering the interests of his or her community. So when you think of a quality education, some of people talk just about the money, the $350 million or so that may be required to be raised to fund quality education here in Montana. But rather than just thinking about the money, think about the social and human wealth created if we in fact provide the type of education for all children, Indian and non-Indian, in our K-12 system. The next issue I'd like to talk just briefly about is going beyond the K-12 system. Remember I mentioned to you that Brown struck at the heart of the segregationist theory, struck at the heart of the idea that you should separate children by race. And that the response to this to say, well, the only basis on which we can have human community free of racism is to have those children attend schools, worship together, work together, play together. Let's think now beyond K-12 to what's called higher education. All of us know that K-12 is very important, but we now know, and I suspect many of you have taken advantage of the higher education system that provides professional and further opportunities. I'd like to comment just very briefly on the recent Supreme Court decision decided not 9-0, decided 5-4, called Guter v. Bollinger. Those were companion cases out of Michigan involving the University of Michigan. One of the cases involving the law school, the other case involving the undergraduate college. Remember the monumentalness of Brown, in which 9 justices, 9 cantankerous, crotchety, on occasion mean justices, all agreed that they would remove root and branch the effects of segregation. Look at our court today, struggling to cobble together a bare majority, 5-4, talking about the future beyond integration of diversity. And there was one swing vote, one courageous woman, Justice Sandra Day O'Connor, who I've had the occasion and privilege of meeting on a number of times, or appearing before twice in the U.S. Supreme Court. She was the one vote that swung the vote in favor of diversity, taking us beyond Brown, K-12, to opportunities for minorities in higher education. Now, one might say, and many commentaries have come out already on the 2 Bollinger cases, one of the major reasons Justice O'Connor voted the way she did was because of testimony, because of what they call Missoula briefs from the military, from the Joint Chiefs of Staff, from CEOs of major corporations saying, we need diversity. We've learned from hard experience in Vietnam that a white officer corps won't command the respect of a black enlisted man. We need an opportunity for affirmative action and diversity in the military if we're going to have national security. The CEO said, we need black managers. We need black CEOs if we're going to succeed and compete in a world that's globalized and diversified. Yet it commanded only a 5-4 vote. So when we think about the inheritance, the legacy of Brown, let's not be too smug. Let's not be too overconfident. Let's not forget those giants. Thurgood Marshall, Chief Justice Earl Warren, those very brave named plaintiffs who brought these cases. Let us work today in our own ways, here in Montana, here in Missoula, to carry forth the promise of Brown, to work to make Indian education for all a reality, to work faithfully to make the Constitution promising a quality education so that our children can compete in an increasingly globalized and competitive world. So even though I'm an Indian man, and I grew up on a reservation called Fort Berthold And you got that almost right, in northwestern North Dakota. I'm sort of now a product of a new globalized environment. I married a woman from Long Island, New York. We have 2 kids who think about traveling the world. So even my growing up, never having been further from home for a large part of my life, more than 60 miles away is a little town, or big town, you say, a minor. What I appeal to you is to think about the future. Think about Brown 1 and 2 as sort of a template for how we don't have to have courts order us to do what we know instinctively as a community, instinctively as a society, is beneficial to us. And as I say, some of us in the legal community say, really, the law is shaped and constructed not by law professors, not by lawyers, not by judges, even Supreme Court justices, but it's constructed by us. How we regard one another, how we make Brown a living legacy in terms of our own treatment of one another. And I don't think anything's impossible, despite some of my colleagues' dire predictions about the death of Brown. I think it's up to us. And at least, based on what I've seen in Montana, the recent court decisions, the recent actions that we've taken, the recent grassroots action represented here on the panel, I have a great deal of faith that Brown at 100 will look back on a society in which equality, diversity becomes not just rhetoric, but becomes the actual living flesh of our society. So I thank you for your time.
Putting my water in the throat gets dry. So, I want to thank you all for coming out, giving up your Thursday, Wednesday evening to spend with us. I thank Professor Cross for those great words, and I know Joy Jane's going to say even greater things. I'm going to follow along with what Professor Cross did, and I'm actually going to talk more about the grassroots level. So, first of all, I want to say that my name is Janet Archambault Robidoux. I am the daughter of Irene and Merville Archambault. I am the granddaughter of Mary Whistling Elk and Alec Blackhorse. I am a Northern Cheyenne, and I'm very proud of that. But I want to say that it is very easy to focus on the negative, but that in looking back at my own childhood and at the things that we all had to endure in those times, which, by the way, were completely acceptable at the time, that I have to honestly say that we have come a long way since the 1960s Montana that I lived in as a child. I have memories of signs in store windows, mostly in the small towns that surrounded the Northern Cheyenne Reservation where I grew up, that said, no dogs and no Indians allowed. I remember not being able to go into some of the restaurants because the owners didn't want us as Indian people in their establishment. I wasn't sure why, but I remember the names that we were called, and I certainly remember that tone of voice. But we've come a long time from that time in history where the attitudes and the actions were blatant. I attended St. Lebrain Mission School, and I remember that as females attending this Catholic school, there were boys there, by the way, that the jobs that we were encouraged to strive for were actually very few. The door that was open for us was the opportunities that we were encouraged to follow was either to be a teacher, a nurse, or a secretary. And I have to admit, I'm not sure why, but the nuns frowned upon this job. And of course, they encouraged us to be nuns. I frowned at that one. We've come a long way from those days when we as females had these few choices on what we could study and ultimately spend our time working on. I'm going to jump to this this century and say that when I was in South Africa at the World Conference Against Racism, I found out that we as Americans were viewed as just that, Americans. Not one person from another country looked at any of the people in our group and said, are you a Native American, an Asian American, a Hispanic American, an African American, a Latino American? Nope. Every single person that I spoke with from another country looked at our group as Americans. And we were all a delegation of people of color. There was 30 of us. I encountered this same experience when I spent 10 days in Mexico this past October. The people in Mexico that I encountered also viewed me as an American. Not once did anybody in Mexico ask me if I was a Native American or even if I was indigenous. They all looked at me as an American. But I find that in my own country, that it is here where I'm viewed as different. I think of the comments that I hear from various individuals who will staunchly and adamantly state that we, as American Indians, Mexican Americans, African Americans, American Americans, Asian Americans, whatever American, that we need to stop setting ourselves apart and get over it because we're all Americans. But I find that, just as it was in my youth, that people will still view me as different. It's the people in my own country who constantly and consistently point out to me that I am different because my skin is brown. I'm made to feel in this day and age that I am different because my skin is brown. And I have to be honest and tell you that when the people in my own country look at me as an American, then I can say I am an American without having to quantify it or qualify it. I won't have to quantify who I am or what I am based on the color of my skin in my own country. When the time comes when employers look at my credentials when I apply for a job and actually look at what I bring to the job rather than the color of my skin, and they give me the same opportunity that they give the next person, whatever color that person is, then we can do away with affirmative action. But until that time, we need it because I don't get a fair shake. And if you ask other people of color in this state and other places, they don't get a fair shake. Because ultimately, people look at the color of our skin. Yep, we've come a long way from the 1960s Montana that I knew as a child. But if we're honest, we have to admit that we have a long way to go. And we can begin by working together, treating each other with dignity and respect, respecting and accepting our differences. We need to stop letting the powers that be use the divide and conquer strategy against us because we really are all in the same boat. I say that instead of us being guided and driven to turn on one another, let's figure out where, when, and how we can stand together. Because when we stand together, it's more difficult to tear us down. And if everyone of us in this room can make that commitment to work together, we can tell each other, we can encourage our friends, and they can encourage their friends, and we can change it and we can make it better. In my culture, we have an obligation to leave this world a better place than it was when we were here. It is also our obligation to leave this world an even better place for our children and for our children's children. Those leaders, both known and unknown, the same folks that Professor Cross talked about, who came before us, has set a great example that we need to continue to follow. We can all commit to follow through on this. we really have nothing to lose and everything to gain. Racial injustice, discrimination, treating people less than because someone else has labeled them as different can stop with us. We can take the stand and say that discrimination is unacceptable, whether it's because of skin color, age, gender, sexual orientation, weight, eye color, education, financial status, whatever. We need to take the stand that discrimination is wrong. And if we all do it, we can set great examples for those coming after us. We can dare to be different by standing our ground, and believe me, it's not always easy, as many people in this room can attest to. And we can say that we do not accept discriminatory behaviors or actions, period. Eventually, the movement to stand against racism, oppression, discrimination will win out, because we will all contribute to it by taking that all-important step and saying that we do not, and saying to discriminate against anyone is unacceptable, and we won't stand for it. We can stand united in solidarity and make this world a better place for our children and our children's children. A world where acceptance and tolerance is second nature to us all. What a great world that will be. Thank you.
Two great speakers right before me, so I'm feeling really intimidated here. Yate, she yagles barnshna, kini ane ebashchin ado. Oh, let me start that over because I said it wrong. My mother would just really kill me if she heard this. Anyway, it was on my clan, but what I said was Yate at the beginning. I said my Navajo name is Glenaspa, and these are my clans, and they are Kapahe, which is Water Edge, and Kinyaani, which is Towering House. And in my culture, which is Navajo, we always identify ourselves with our clan system. We have our mother's maternal clan and the paternal clan system.
Amen. So she should go. We he jump on when he want to we he go on in soup.
That's it.
In soup.
That was good. I didn't understand that, but it sounded really good. I'm sure it was very positive. Thank you.
Yeah, that was very positive.
Thank you. Just a brief background on myself. I usually don't like to tell people where I've been, but and I'm going to say this only because it leads into where I am as a person today. I went to the University of Arizona for a master's degree in hydrology, and I wanted to become this hydrologist for a long, long time in my life. So I did that. Previous to that, I did a Bachelor of Science in agriculture, and both of these were at the University of Arizona and Arizona State University. And I found my way up to Montana in the late 80s and went to law school here in Missoula. After that, I got a job with the Confederated Salish and Kootenai tribes, working with the government in their legal defender's office. And right now what I'm doing is I have a law firm that I established, and I'm the only person that works in there right now. But that's what I do as a living. I'm also serving my second term in the Montana State Legislature in Arlee. That's my area. I will be running for a third term this year, 2005. Fortunately, I've been unchallenged. I'm not challenged. I guess I just feel very fortunate because the people in my district, it's a new district, but I believe that they thought that I was doing a good job and that I was probably going to work my my butt off because I was going to do that if I did have a challenger. What I wanted to start with is that when my father was, this is interesting, but when my father was just 2 years old, nobody, I mean Indian people could not vote. When he was 2 years old, he couldn't vote. 1924, I think that's the right date. At least that's what I have. That's what I remember. Can you imagine that? 15 years later, my father enlisted in the United States Navy and served. He got, honorable discharge. My grandparents, my grandfathers, none of those individuals, none of my relatives before my father's generation could vote. Can you believe that? 30 years after the Indian people were allowed to vote, Brown versus Board of Education was decided. And as stated by Professor Cross, he mentioned all of the justices. What I wanted to stress to you is that one other item was that 86 years after the Navajo Treaty was signed, Brown versus the Brown case was decided. 99 years later, the Hellgate Treaty, after the Hellgate Treaty was signed, Brown was decided. So, I mean, we kind of put that in perspective. You know, what is going on in history? What was going on in Indian country when Brown was decided? Those justices were great in their day, and I won't repeat what Professor Cross said earlier. However, we have to remember Chief Charlo, Geronimo, Chief Potomac, Chief Manuelito, Chief Old Elk. We had all of these chiefs that decided for the Indian people what those treaties were going to contain, what the terms were going to contain. And so we, in my life, and Indian people, I know that the two individuals here joined me in contribution, in tribute, to these chiefs that did their share so that we could have the land that we have, the education that we have. There was a whole lot of resources that were lost when those treaties were signed. However, it is pretty much the law of the land. Naturally, it's being chipped away. It's being challenged by different factions in the United States right now. The Supreme Court is always, I believe, looking at a way to chip that away from us. But history is there. History is something that we can hold on to. We can say to our children on the Flathead Reservation, okay, Chief Charlo did this for us. We have to remember him. This is what he stood for. Regardless of what the United States Supreme Court is doing, regardless of what the federal judges are doing in our two Indian country today. Other dates. I kind of like to do figures. I'm not a mathematician or anything, but imagine this. 512 years later, after 1492, there is still terrorism in the United States. 512 years later, 1492, Columbus supposedly arrived in the Americas. Terrorism still exists. It still exists in the form of alcoholism. It exists in the form of drugs, unemployment, diabetes, high unemployment rate. All of these are prevalent in Montana on the 7 Indian reservations, and it's prevalent across Montana, I think, and it's prevalent across the United States. So what I wanted to talk to you about today was that some of the decisions that courts are making today affect us all the time. Won't go through that because Professor Cross went through that. This morning, up on the Flathead, we had a walk. We had a 5-mile walk. We went from Ronan to Pablo. We had people, the community organized a walk because of what has been happening on the Flathead Reservation. There's been deaths, there's alcoholism, there's homicides, and Flathead is not singled out. The other reservations have it. We have it in Missoula, we have it in Billings, we have it everywhere. We have it in the United States. So what we've been doing up here is that we've been having community meetings so that we can address what can we do with our youth? What can we do so that we can fight this terrorism that we are living with every day? We had 200 to 300 people this morning turn out because we believed in our youth, because that's what we feel is where we need to reach out to. There's lots of dysfunction. There's a lot of dependence. However, there is also good news, though, because we have people like yourselves, we have people here that are looking out for interests of those people who are and could be disadvantaged. Not disadvantaged because they want to be, but disadvantaged by a system that still exists today. The same system that existed in 1954 when Brown versus the Board of Education was decided. It's not called segregation really anymore. It's still here though. Janet hit the nail on the head. Racism exists today. When I went to law school here, I came to Missoula for the very first time. I came to Montana for the very first time. I felt that I was discriminated against, not necessarily at the school, but just in Montana. And I'm thinking, I'm from New Mexico, and this is happening to me in Montana. We kind of dealt with this, when I was like 4th grade or whatever. So like, it was 20 years later as an adult, and I'm thinking, oh my gosh, now I can actually say something, because when I was younger, I didn't have anything. I couldn't say anything because I was so young. So, but it exists right now. However, the way to overcome that, and what I've done with my life, and I believe that I am setting an example for all people, not just Indian people, but just children on the Flathead. When I got elected, they were saying, oh, there's Joey Jane, and I felt like, because I'm a really actually a shy person. And it was interesting for little kids to recognize my name and for them to say, that's her. And so one of the challenges that we talked about today up at Flathead was just setting an example of being mentors, because these are some of the positive steps that we can take to fight all of these things that I talked about. Brown, the racial inequality, the injustice, equal protection. I think there was something in the newspaper just recently about renters in Missoula, where indigenous or Indian people were told, it was full and it really wasn't. I mean, it still exists today, but I believe that, I guess I'm just a positive person. I'm a positive person in the sense that, okay, that exists, we have to recognize it, and we have to just set an example. There's probably just a few people that do that. I think Missoula is a good town. I don't believe that it's, I think it's more accepting, more liberal than, say, Billings or some other place. That's just what I feel about the community. Something else I wanted to bring up was during the day today, we had a couple of the children talk. They were 15 and 16-year-olds talking about their parents having had chosen alcohol over them, having chose drugs over them, having had to choose. And so it exists today. It's really real. We had 15-year-old, 16-year-old talk today about how the grandparents are coming in, how the relatives are coming in. And that's a positive thing, how we can help our extended family members, so that we're trying to help all of our children at this time. It's a huge problem. Having served in the legislature is a great pleasure. This last session, 2003, I served with 6 other great Indian legislators, and I was so privileged to be with them. And this coming session, if we have 2 more that are successful in winning their races, which they should, we will have for the first time 8 Indian legislators in the state government, 2 senators and 6 representatives. And that is historic, because we are there to watch out, not just for Indian children, Indian families, but just to watch out, because like Janet said, let's be Americans, let's not look at each other. And so one of the ways that we do that is to educate the legislators. We are trying to educate the legislators, be professional. We're trying to educate them so that they have this understanding that not everybody on the Indian reservation is lazy, and that not everybody is just wanting, free this or that. Because that is prevalent in the legislature. Just one session ago, we had a senator said that, I don't remember the exact words, because I didn't want to memorize it. It's something about the Indians were living in ghettos. Something like that. But we asked the senator for an apology. He gave it to us. So we are there, and imagine if there was no Indian legislators there to tell him, hey, you know, you owe not us an apology, but you owe Indian people and people of Montana an apology. Rather than trying to put blocks up, you know, let's work together. So it's been a great pleasure working with the legislature. I believe that we are making great strides in being there, and you know, we're also trying to watch out what the Montana Supreme Court is going to do this in any session here, you know, in terms of Indian law also. So we're, you know, looking at all of that. And with that, I would like to conclude by saying that it's a privilege to be here tonight. Thank you for your time. Thank you for allowing me to share a piece of my life with you, share a piece of who I am. And I would like to thank you for having me.
We have some time for some questions. Does anybody have a question? If you do, raise your hand and you can direct it to one of the panelists.
My question's for Judy? Janet, sorry. You said that you know, you saw those signs when you were younger, and then now we obviously don't see them anymore. What do you think it was that, you know, helped people take those signs out of their store windows and things like that? And also, what sort of outreach work do you think we need to have happen today to educate people to sort of like destigmatize, you know, Native Americans into our culture?
I think that part of what I think it gives me a chance to yell. I think that part of what led to those signs coming down was the civil rights movement of the 60s. I think people just recognized that that was not publicly acceptable. I think that Joey Jane, you know, the part of the work that we do in Indian People's Action and Montana People's Action is deal with the lack of awareness that many people have about poor people or about us as Indians. And I find that in this day and age, 2004, that people actually still believe that we all get a check every month from somewhere, we all get free education and, you know, free whatever. And I find in the work that I do in fighting for racial justice and equitable rights for low-income people, that when somebody else thinks that somebody else is getting a bigger piece of pie than they are, then that leads to us fighting over these little pieces of pie. So I think part of it is letting people know the truth. It's like we don't get a check every month. And if we do, and I haven't been getting mine, I want it. It's just, I think it's just education. And people also I'll just wrap this up. People need to feel free to answer the questions. Let me just stand up. People need to feel that it's okay to ask the questions. I mean, the last thing that somebody needs is if you come up to an individual and say, well, is it really true that you get a check every month because you're an Indian? And you turn around and you say, well, that's the stupidest thing I've ever heard. My goodness, it's 2004. You know, who told you that? Well, that makes us a lot of friends if we do it like that. It's really giving people the freedom to ask those questions. And once they can get that awareness and get those questions answered, I find that they're more willing, more accepting, and more able to work side by side with us, which is our ultimate goal.
Do you have any other questions?
Yeah, I think any of you can answer this, but I think probably Professor Cross might be able to address it maybe. And I think it's the first article of the state constitution where it references that the jurisdiction of Indian lands belongs to the United States Congress. And then when we go to Article 10 in regards to equal and quality education, is there any kind of a conflict there? Is that an asset to helping with problems in education on the reservations, or is that something that is going to be an obstacle in dealing with the state providing quality education in those areas and dealing with the federal jurisdiction in there?
Well, it's interesting that you should mention that disclaimer. It's called a jurisdictional disclaimer as a condition for admission into the Union. All of the western states, with the exception of Colorado, had to disclaim any jurisdictional authority over Indian country within its borders, and that appears in the state constitution and the corresponding enabling act. Has it had an effect? It indeed did. I took a look at some very ancient, well, antiquarian legal documents before I came here, and it's interesting because way back when, in about 1935, 36, 37, there were a series of opinions from the Solicitor Department of the Interior. Montana, among other western states, were refusing to allow Indians who resided within any country, allowing them to vote in state elections, despite the Citizenship Act of 1924 that Representative Jane alluded to. And one of the things he pointed out was that the jurisdictional disclaimer related to taxation issues, related to those types of issues, didn't relate to the human civil rights aspects that the Indians were guaranteed along with other citizens of the United States. Those sorts of jurisdictional ambiguities are many times used by states, most recently down in New Mexico, not allowing Navajos to go. So harmonizing the ideas of the Indian people, Indian country, within the state borders of the states, very difficult, still an education going on. But you brought up an interesting point. Article 10 means what it says. It's only recently being implemented. Recent Supreme Court decisions have clarified what the jurisdictional disclaimer means. So we're making small bits of progress. But the points that you bring up, sometimes these conflicts seem to appear real, and other times they appear contrived. But I hope that's an adequate answer.
Next question?
I'd just like to ask Representative Jane, are there any specific pieces of legislation that are coming down the pipe of the next legislature dealing with Native Americans and issues of equality that you know of? Talk about that a little bit.
There were some bills that went into the whole pot this last session, and I don't remember the total amount that went in, but there was only a very few that got passed. And so I do know that we will have a lot of legislation. I don't know what any of the specific ones are. Having 8 legislators, we probably have a lot, and I know that Representative Carol Jr. just walked in. I'm sure she's working on some of those, right, probably has a lot of ideas. So I know that we will have some specifically. I think one of them would be getting more funding for college, the Indian colleges in Montana. So, I don't know if you want me to get into more detail than that, but basically, yes, we do envision that we will present bills that we hope to pass. It depends on, passage really actually depends on one who has leadership or who has a majority. That's what we found out. And then also just the success that we're having. Sometimes some of these bills take 2 or 3 sessions to get passed. And it's just a matter of plugging along and trying to educate all of the legislators as to the benefits of any of the legislation that we put through.
I think we had a question down here. Yeah, I did. For Janet. Your experiences at the mission school that you went to, you said, was that when you were younger? Okay, did that lead to your activism? Did that have any role in your choice in what you're doing now?
Oh, yeah. And that's exactly why I do what I do. So the short answer is that I grew up in an atmosphere where we were told no and never told why. And so when I graduated, I decided no one was ever going to say no to me again, which of course is unrealistic because people say no all the time. But yeah, that was the catalyst because people made decisions for me without ever getting any input from me. So it was the catalyst that got me into this work.
Yeah, I wanted to share my perspective. I wanted to go to school when I was 4 years old. My parents told me I was too young. But basically, what I recall about my childhood was they stressed education. And my parents were the one that really protected their 11 children. Just protected us. And they took the brunt of boarding school. They took the brunt of all of that. So it's not a complete contrast to Janet's story. My life was, I wasn't sheltered. I lived on a reservation. I went to reservation schools, but I felt like that my family was the one, my parents were the ones, and I was very fortunate to be the ones that were in between us and the world somewhat. I mean, they were there to hear these things from these people. So.
You young people will take up the cause, and I know that Hellgate in particular is very active in diversity efforts, and I'm very pleased to see you here. Thank you. Thank you very much.